All right. Good morning, everybody. Welcome back from the break. My name is Jessica Moore, and I'm one of the attorneys here at Abdenor Weicker. I'm based out of our Columbus office, and just generally, I represent both students in K-12 schools as well as in higher ed, and specifically help with matters related to K-12 student discipline, Title IX for all students. In the higher education realm, I help students with code of conduct matters, academic misconduct issues, grade appeals, dismissal appeals. Visually, I have longer light brown hair. I'm wearing a light blue top with a light gray blazer. Today, we're going to close our series on the Title IX grievance process. If you've previously attended our last two conferences, we've discussed Title IX in general, the complaint process, the investigation process. Now we're going to cover what happens after the investigation and really focus on hearings, the decision-making process, and appeals. For those of you who have not attended our last two conferences, I will briefly cover where we've been just to set the scene for what we are really going to focus on today. Okay, so when we talk about Title IX, what we are talking about is Title IX of the Education Amendments of 1972, which states that no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subject to discrimination under any educational program or activity receiving federal financial assistance. That is it in terms of what Title IX states. However, a lot of what we are going to really talk about is fleshed out further in greater detail in the Title IX regulations. So when we're talking about the Title IX grievance process, what we're really focusing on are cases involving sexual harassment. And so sexual harassment under Title IX is very specifically defined. So this can include conduct on the basis of sex that constitutes either quid pro quo harassment, unwelcome conduct that is determined by a reasonable person to be so severe, pervasive, and objectively offensive that it denies a person equal access to the recipient's educational program or activity. This can also include sexual assault, dating violence, domestic violence, or stalking as defined by the Clery Act. So when we're talking about the specific stages of the Title IX process, we really start with when a formal complaint is filed. So a formal complaint is a document that's either filed by a complainant or that is signed by the Title IX coordinator alleging sexual harassment against a respondent and requesting that the school investigate the allegations. When we talk about a recipient, that is essentially the school that is receiving federal funding. A complainant is the individual who is alleged to be a victim of conduct that could constitute sexual harassment. And then the respondent is the individual who has been reported to be the perpetrator of that conduct that could constitute sexual harassment. Once a formal complaint is filed, the school should send a notice of allegations to the parties. From there, they must then conduct a thorough investigation. This can include interviewing parties and witnesses, gathering documentation, and then allow the parties to respond to the evidence and then the investigation report that the Title IX investigator will create. So we have covered those in prior conferences. Today, what we're going to focus on again is what happens after that investigation is over and we move into a hearing and decision-making stage. So when we talk about hearings, we're going to talk about both higher education schools and K-12 schools separately because there are some differences in what is required in terms of the grievance process. So with post-secondary schools, for these colleges and universities, a live hearing is actually required. Now, these hearings can be conducted with parties physically present in the same geographic location, or hearings can be held virtually. What the school must do during these hearings, however, is create an audio or audio-visual recording or transcript of that hearing and make it available to the parties for inspection and review afterward. So when we look at the Title IX regulations and what is required in the hearing, the only aspect of the hearing that is actually required under Title IX is the ability for cross-examination. So at the live hearing, the decision maker shall permit each party's advisor, which I'll talk about in a second, to ask the other party and any witnesses all relevant questions, including those that can challenge credibility. This cross-examination must be conducted directly with the party or witness, orally and in real time. So again, when we're talking about these live hearings, and again, these questions must be asked by the party's advisor of choice and not by a party personally. So in these hearings, parties are not communicating with each other. They are not communicating directly with witnesses. All of these questions have to come through the party's advisor. Now, under Title IX, students can have an advisor of their choice. It could be a parent, it could be a friend, it could be a teacher, a counselor, someone that they trust, or it could be an attorney. Okay, so there is no limitation there on who can serve as an advisor, specifically in the Title IX process. That is very different than other types of grievance processes that students sometimes face, particularly in higher education settings. If a party does not have an advisor, so for example, if they can't afford an attorney, or maybe they don't want to tell their parents that they are being accused of something, or they don't want to tell their friends, they want to keep it quiet. If a party does not have an advisor, the school must provide free of charge an advisor who may be, but is not required to be an attorney, to conduct cross-examination. Cross-examination. Again, parties are not permitted to question other parties or witnesses. So when we're talking about cross-examination, the other issue that largely comes up quite a bit is the issue of relevancy. So only relevant questions may be asked of parties and witnesses. And so before a question is answered, the decision maker must first determine whether that question is relevant or whether it is not relevant. If a decision maker determines that a question is not relevant, the decision must explain the decision to exclude a particular question and give a rationale as to why it is not relevant. In reality, what happens in these cases is that so long as the question is related to the allegations or any potential defenses or credibility, the question is very likely going to be allowed simply because the formal rules of evidence do not apply. However, there are several types of questions that are either automatically not going to be considered relevant, or that may not be under the circumstances. So one example of this is that any questions about a complainant's sexual predisposition or prior sexual behavior are never relevant and are never allowed to be asked unless those questions are offered to prove that someone other than the respondent committed the conduct alleged, or if the question concerns incidents of prior sexual behavior with the respondent and are offered to prove consent. Those are the only two exceptions for when questions about complainant's sexual predisposition or prior sexual behavior can come in. What is interesting is that this limitation does not bar questions of respondent sexual predisposition or prior sexual behavior. Those questions are not technically prohibited under Title IX. However, in practice, if those questions are not relevant to the accusations that the decision maker is hearing, then they still may be deemed not relevant by the decision maker. But again, they are not expressly prohibited under Title IX. Other types of questions that typically are deemed not relevant are questions that relate to information that is protected under a legally recognized privilege, right? So I'm thinking doctor-patient confidentiality, attorney-client privilege, those types of privileges, spousal privileges in some instances. Those types of questions that would potentially violate those protections are generally not permitted and allowed. Also, information that pertain to specific medical records, psychological records, mental health records of the individual are not permitted unless there is consent by the person who holds that specific privilege. That being said, in these hearings, every case is very different, and every decision maker will have a different experience in who advisors are and what types of questions come about. But decision makers may deem that, repeated questions, that are intended to badger parties or witnesses may eventually be deemed not relevant, even if they were initially. Questions that are harassing in nature, or that don't really pose a question, but rather are making a statement and then, saying, right, at the end may not be deemed relevant depending on how it is asked, and especially how often it is asked. So one thing that is important to note here in these hearings in particular is that parties and witnesses are not required to participate in the Title IX process. There are a lot of reasons for that. And just some examples can be, it's a very overwhelming process. You don't want to see the person who you are accusing. You don't want to see the person who is accusing you. You from an emotional standpoint, cannot be in that hearing and do not want to participate. It can also mean that if you're a respondent and maybe there's pending criminal charges, and so you have an attorney who's advising you not to participate, because anything you say in a Title IX hearing could be used against you potentially later in a criminal case. And so folks that are respondents actually really do need to be careful about this, especially depending on what the allegations are. But under Title IX, parties and witnesses are not required to participate in the Title IX process. And when I say participate, what that means is that it could be not attending the hearing at all, or attending the hearing, but just not submitting to certain cross-examination questions or any cross-examination. That is allowed. The decision maker can still rely on previous statements made by that party or witness in the investigation. So if a party does not participate or a witness does not participate in the hearing, but they've participated in an interview, the decision maker can still rely on those statements made in that interview when making that final determination. What the decision maker cannot do is the decision maker cannot draw an inference on responsibility solely on that party's or witness's absence from the live hearing or the refusal to submit themselves to questioning. So the fact that someone is not there or not participating cannot make a decision maker draw any negative inference for that. What I do typically tell people, however, that are not participating, and again, this is a large balance that every case you have to really determine what is best for your client, or if you are a student, you have to decide what's best for you, because not participating can still have effects, right? If you do not participate and the other party does, depending on what you may have said in the investigation, may or may not be helpful to you. And without having your side, sometimes the decision maker is left with only one side of things, right? And depending on the circumstances, that could potentially lead to a finding not in your favor. So, it is a balance, and every case is very, very different. So when we're talking about preparing for a Title IX hearing, what is important to consider is what the hearing is actually going to look like. So everything I just talked about in terms of cross-examination, again, is the only aspect of the hearing that is required specifically under Title IX. Nothing else. And so outside of that, every school handles Title IX cases very differently. Some schools, handle them pretty similarly, and others do things that you may never see before. So it is very important that when you have a Title IX case that you are considering the school policy and what their policies allow in terms of the process and what they require in terms of the process. Because again, every school can be different, and these aspects that I'm about to talk to you about are not necessarily required under Title IX. So the first is pre-hearing conferences. So prior to a hearing, what many schools will do is hold a pre-hearing conference with the parties and their advisors and talk about the hearing. So this is where you will meet the decision maker and talk about the hearing procedure, what to expect procedurally. Many times this is the hearing or the meeting, I should say, where you will get most of your questions answered in terms of what to expect at the hearing. But this is a good time to really ask these questions and find out what is allowed in the hearing so you can best prepare. So in these meetings, typically a decision maker will go over the procedure. They will go over the hearing decorum guidelines and all of the rules, which are essentially just be respectful, no harassing behavior, speaking one at a time, all of those things. But they will also sometimes do a couple other things. Sometimes they will ask you at this point if you would like to invite any witnesses to participate, and that is your time to really specify who you would like to attend on your behalf. They'll talk to you about whether that's the school will invite these witnesses or whether you need to separately invite these witnesses. They will talk to you about questioning, right? And they'll kind of go over the rules, everything I just talked about in terms of cross-examination, the fact that only an advisor can ask questions, and that an advisor cannot speak for the student, even if they are an attorney, which is very important to consider. But also, some schools will invite you to create a list of your questions ahead of time and turn them into the decision maker, sometimes even at this pre-hearing conference. So the decision maker can go through those questions that you intend to ask one by one and determine if they're relevant or not. One thing to keep in mind here is that many schools that do require questions be submitted or suggest that questions be submitted, they will never tell you that these are the only questions you can ask, right? And that makes sense because when we're in a hearing, additional things pop up, right? You may have a list of general questions that you want to ask a party or witness, but there's going to be follow-ups, or maybe you change some of the questions based off of what someone has said in an opening statement, right? There's a lot of factors here. And so, if a school is encouraging you to submit a list of questions ahead of time, one, typically it's not required. And second, you will always have the opportunity to be able to ask additional questions in the hearing. So when we're talking about these pre-hearing conferences specifically, I recommend going in with kind of a list of questions that you will want to ask the decision maker that will help you prepare for that hearing. The other aspect of, something to consider when you're preparing for these hearings are whether or not the school will allow a party to give opening and closing statements. So most schools, in my experience, do allow parties to give opening and closing statements. However, I have had a couple cases where the hearing officer does not allow that, right? And the rationale behind that from this particular decision maker that I had most recently was that the hearing is not the part of the process where you are going into every single detail necessarily about everything, right? And the investigation and that investigation report that summarizes all of the evidence that you previously provided is part of the record for the decision maker, right? So some decision makers don't feel like it is necessary to have the parties give an opening and closing statement of their position because they already have that information. Now, that is, in my experience, much more rare. Typically, and a decision maker is going to allow the parties to give a brief opening statement at the beginning and then a shorter closing statement at the end. But again, you want to ask that question. You will also want to ask in relation to this if there are any time limitations for these opening and closing statements, because some schools will say, no, you can speak as much as you want, as long as what you are saying is relevant to this case and not otherwise inappropriate. Other schools will give you very specific deadlines, like 10 minutes for an opening, maybe 5 minutes for a closing. And again, there could be any sort of number, you just fill in the blank. But it's really important that you know what that is before you go into a hearing, right? Especially if you are advocating for a student and you are that student's advisor. Sometimes, depending on your role as an advisor, for me, I help students prepare these statements, right? So as I'm preparing, it's helpful to know how long that can be. And then depending on the advisee, right? If they are reading a statement and they're a fast reader and you know that they're going to go through everything more quickly, sometimes that statement can be a little bit longer. But if they are a slower reader, or if you know that they are going to be very emotional and may stop and take a few breaths, you may want to shorten up that statement just to make sure it complies with that time limitation if there is any. The other thing to consider that schools do very, very differently when it comes to opening and closing statements is that some schools require these statements to be given in writing to the decision maker prior to the hearing. I've had that come up once before. This is not something that comes up altogether too often, but sometimes it is required and can be helpful if you need to know that ahead of time. Again, you want to make sure you are following all directions, so then the student you're advising is able to follow all of those and really be heard and not miss an opportunity. One thing you want to also consider as you're preparing for a Title IX hearing is whether or not you will be, as an advisor, would be able to ask your advisee questions. In my experience, most of the time, direct examination of your own advisee specifically is not. And the rationale behind that is that typically the information that you will want to pull from your advisee is largely going to be the same information that is made in an opening statement, right? And so typically, if decision makers find that it's not necessary, and it can also prolong the hearing significantly, and these hearings are sometimes also very long. But some schools will allow it. I had a case recently where a hearing officer did allow it. And so it's important, again, as you're preparing, that you know whether or not you can question your own party and come prepared with those questions. Lastly, schools will typically allow students to provide either an impact or mitigation statement. So an impact statement is a statement for the complainant to write that does just that, describe the impact that the respondent's behavior had on them, right? And really go into that detail of those effects. A mitigation statement is a statement for the respondent to make where they offer any sort of mitigating circumstances where, if they are found responsible, the decision maker can consider when determining an appropriate sanction. Now, typically these statements are not required, but many schools will allow parties to provide them if they would like. In my experience, these statements are not considered in the hearing itself when the decision maker is determining responsibility or whether or not the student violated this policy. Typically, they are only considered if the decision maker finds a respondent in violation of policy and they are trying to determine a sanction. That's where those statements usually come in. But decision makers that do ask for these statements still handle them very differently. I go into some hearings and the decision maker wants the student to read them in the hearing just at the very end. And then you have some hearing officers who say that they don't want to see them because they don't want what is said to affect their initial decision. And so they instruct the parties to submit them after, or to submit them to the Title IX coordinator for consideration. So again, it's important when you are preparing for your Title IX hearing to ask some of these questions. What is allowed? What is not allowed? How does the procedure look? Because again, outside of the cross-examination, which every Title IX hearing has, nothing else is required under Title IX. And so every school can handle things very, very differently. Okay, so that is the hearing process in general when we're talking about higher education schools. I want to switch gears a little bit and talk about what happens in elementary and secondary schools. Because the requirements for this stage of the grievance process are very, very different. So hearings, again, for these elementary and secondary schools are permitted, meaning that schools can have them if they want, but they're not required. And so in my experience, most K-12 schools actually do not hold hearings. And there's a few different reasons for this. But sometimes you are dealing with also very young children, and so that can complicate matters. But typically in a K-12 school, you're not going to have a hearing. But again, you want to look at school policy, because if the school wants to, they could. With or without a hearing, after the school has sent over that investigation report at the very end of the investigation to the parties, and before they make that determination, the decision maker has to give each party the opportunity to submit written relevant questions that a party once asked of any party or witness. And so this kind of gets back to that cross-examination piece that we talked about in live hearings. The same is true for K-12 schools, except for K-12 schools, there's typically not a hearing. So the cross-examination, if you want to call it that, is coming in writing typically, and it's going through the coordinator usually. So parties can submit those questions within a certain time frame. You will have a deadline of when to submit them, but it's happening that way versus in a live hearing where questions are being asked and answered in real time. And again, I think for especially the younger students, that creates an environment that is certainly less intimidating. Under Title IX, when a school provides the parties the opportunity to submit those questions, the coordinator must then give to the other party what those answers were, and then to allow for additional limited follow-up questions from each party. So there's going to be in K-12 schools a bit of a back and forth in writing in terms of questions back and forth, answers being submitted, and then some limited follow-up questions. But the school will usually create very specific deadlines for this. And especially when we're talking about those follow-up questions are usually done within a shorter time frame. So for example, I've seen a school say, here's the report, you have 10 business days to provide me with a list of questions that you would like asked of another party or witness. And then when the school gets those answers back, they will send it to the party and say, now you have 3 days to ask any follow-up questions, right? And so again, the school has a lot of discretion in providing those timelines, but regardless, they have to provide the parties the ability to essentially ask another party or witness those questions. That being said, even though this is not done through a live hearing, typically, the decision maker still has to make relevancy determinations as to each question. And so the rules that I talked about in terms of complainant's prior sexual predisposition or history, or some of those other scenarios that make questions not relevant, those will still apply in these settings. Again, it's just typically done in writing. After this step, especially for K-12 schools, just like a hearing, the decision maker typically will issue that written decision. Okay, so here's our poll question. So true or false, the decision maker can be the same person as the Title IX coordinator or the investigator. Give people a few seconds. Whenever you're ready, we can move on to the next slide. Okay, so when we're talking about the decision maker, no, the decision maker cannot be the same individual as the Title IX coordinator or the Title IX investigator. And there are a lot of reasons for that. Now, this has shifted as the regulations have changed, but now that we are back to enforcing the 2020 regulations, this is the policy that currently exists. So again, the Title IX coordinator and the Title IX investigator cannot also serve as the decision maker in Title IX matters specifically. Now, when we're talking about a decision maker, this can look a little bit different. So it could be a single decision maker where one person is just making that decision. It could be a panel, and that panel can have as many people as the school wants them to have. I've seen anywhere from 3 to 7, but typically 3, I think, is more common if you're having a panel. But that's what that can look like. And when the decision maker is making their decision under Title IX, they must apply the correct standard of proof in issuing that final determination. And this standard of proof, it can be one of two. It can be the preponderance of the evidence standard, which means simply is it more likely than not that the respondent engaged in the behavior that they were accused of and violated policy. Or it could be the clear and convincing evidence standard, which is a slightly higher burden of being highly probable. Both are certainly far lower than that beyond a reasonable doubt standard that you see in criminal cases, but the school must issue in their policy which standard of proof they will apply in these cases, and then that decision maker has to then apply that correct standard of proof in issuing its final decision in any case that they have. So I want to talk about what the written decision looks like. Now, this is going to be the same in either a K-12 case or a college or university matter. So, the type of school it is, frankly, does not matter. But some of the requirements for this written decision. The decision maker must identify the allegations and list out what they are specifically. They must describe the procedural steps taken, and this is from the start of the complaint, from when the complaint was first received through the determination. So this includes notice of allegations being sent to the parties, interviews with parties and witnesses. Some schools will be very specific in terms of, the people that they are reaching out to and when and how many times and whether a person declined. Some are more specific than others, but that has to still be documented. If there were any site visits, that should be noted. Any methods used to gather evidence, any meetings that are held, any responses that were given through that investigation process, and then the hearing as well. The decision must include the findings of fact that support that determination. So in Title IX processes, there are a lot of facts that come to light. And some of these facts are related to the allegations, but they may not make or break a decision, right? So, when we're thinking of a case of sexual assault, for example, and we are, without going into detail, when a decision maker is considering what happened, for example, let's say in a dorm room, there may be some aspects of things that don't matter. But what the decision maker should be doing is really listing the findings of fact that directly impacted the decision, what those were. Some decision makers will specify what is disputed versus what is undisputed. And then again, listing out the facts that they consider. The decision maker should also include in this decision conclusions regarding the application of the code of conduct to the facts, right? So again, typically decision makers are making 3 different decisions as they write this final determination. One is, did the respondent engage in the behavior that they're being accused of? The second is, if the answer is yes, does that behavior constitute a violation of policy? Sometimes it does. Sometimes it doesn't meet that definition, right? And so again, there's kind of 2 very distinct decisions there that the decision maker has to consider. Maybe the respondent did that thing, but it may not be sexual harassment under policy, right? And so the decision maker has to really evaluate that. And then the third is, of course, the sanction, which we'll talk about in a second. But the decision maker has to really flesh out, based on those facts that they just stated in their decision, what those conclusions are as it pertains to each and every allegation. So some of these cases will have years worth of allegations, right? The decision does not have to be the same for each and every allegation. So a decision maker has to really think through fact by fact, allegation by allegation, what their decision is and why. And again, does that violate policy? And again, they have to give that rationale. That third decision that the decision maker really needs to make is if the decision maker has found that the respondent is in violation of policy, what does that sanction look like for the respondent? And then what type of remedy, if any, can be provided to the complaint? And they make that decision as well. Now, some schools have policies that will say the decision maker, while they can make that decision, particularly as it pertains to sanctions, maybe they have to coordinate with another administrator at the school to get additional information, right? If the respondent has had prior violations before, sometimes it takes in consultation with someone at the school to provide that information that the decision maker will need to make their decision on a sanction. Some schools will say a decision maker can, again, make that recommendation as to a sanction, but it has to be approved by another administrator at the school. Again, typically that only applies to sanctions in particular, but the decision maker is making a decision or at least a recommendation as to all of those things. What the decision also has to really flesh out is the procedure and the permissible bases for the parties to appeal. That information does have to be included in that written determination. Okay, so when we're talking about an appeal, so again, the investigation is done, the hearing is completed, and the decision is made. Under Title IX, both parties will have to be offered the opportunity to appeal. And under Title IX, there are 3 very specific grounds that the school has to provide the party to appeal on. So one ground to appeal is on if there's a procedural irregularity that affected the outcome of the matter. So this is really when we're talking about procedural issues, but again, for a decision to potentially be reversed or for the case to be remanded for a new hearing, it has to have affected the outcome. So we are not talking about minor procedural defects. We're really talking about substantial procedural defects here. The other ground that is required under Title IX is new evidence. But that is new evidence that was not reasonably available at the time the determination regarding responsibility was made, and that could affect the outcome of the matter. So it's not just any new evidence that a party wants to throw out there. It has to be one that you did not have before, right? So it can't be something where maybe you want to change strategy and bring in this additional document or this additional photo or video that you think proves your claims. If it existed at the time of the hearing, you're not going to be allowed to now introduce it as a basis for appeal. Potentially, unless you didn't have it at the time, again, it has to have been reasonably available to you at the hearing. If it is, then you can't bring it in. And again, that new evidence must be of such a nature that it could have affected the outcome, right? So again, it has to be relevant that may change things. The other ground that schools have to allow parties to appeal on is if the Title IX coordinator, the investigator, or the decision maker had a conflict of interest or bias for or against complainants or respondents in general, or the individual complainant or respondent. And again, that conflict of interest or bias must have affected the outcome. So those are the 3 grounds that the Title IX regulations specify that schools must allow parties to appeal on. However, this is where you really need to consult with the school's policies, because some schools, not too often, but it does happen, some schools will actually allow parties to appeal on additional bases. And so you really want to review those, especially because not all cases and not all circumstances fit under one of these 3 grounds, right? And so before you give up or before you tell a party, look, you have no basis to appeal, consider what the school's policies are, because you may be surprised and there could be other grounds that could be helpful. I've seen particularly for respondents, if a sanction is disproportionate to the violation, It could be a whole host of things, but again, you really want to review those policies. Okay, so when we're talking about an appeal, again, you have those grounds to appeal. So typically, a school is not just going to let you appeal just because you disagree with the decision. It has to fall under one of those specific grounds. But there are still specific requirements for an appeal. So a school must notify the other party when an appeal is filed. So if a complainant filed an appeal, they must let the respondent know that. The decision maker must, or not the decision maker, I'm sorry, the school must ensure that the appellate officer, the person who is making that decision on appeal, is not the same person as the original decision maker, which makes sense, the investigator or the Title IX coordinator. So again, they have to appoint a new person to serve in that role. They must give both parties a reasonable and equal opportunity to submit a written statement in support of or challenging the outcome. So typically when a party submits an appeal, they will then get a notice that they can provide a statement. But typically at that point, it's not necessary because they've already filed the appeal that states their decision. But essentially the non-appealing party would then have an opportunity to, respond to that appeal and kind of give their position. And then that decision on appeal has to be provided in writing simultaneously to both parties. Once the appellate officer has made that final decision, typically, and frankly, in every case that I have seen, the appeal is going to be final, and that will be the end of the Title IX process through the school's administration process. And then typically, if there are any issues, you would have to consider what potential next steps you have outside of the Title IX process. So that is it in terms of the Title IX grievance process. I know we covered a lot these last 3 years. If I could give you really one key takeaway from today's presentation is as you are preparing for a Title IX hearing, in particular, make sure that you are reviewing the school's policies and asking questions as to what is required, what is not required by that school, because again, every school will handle these cases very, very differently. And sometimes even within a school, sometimes decision makers will handle things very differently. And so it's important that you are looking into policies, but then also asking questions about what certain preferences are by that decision maker, because again, that can vary. And don't get too complacent. Schools change these policies all the time. And so if you have assisted a student at a particular school, in 1 year, the next year, you may be looking at a different policy. And so continue to educate yourself and making sure you're really familiar with these policies, especially as you're advising students, because what I find is that these students are really looking to you as attorneys to help guide them through this process. It's very scary for both parties involved. And so the more we can be knowledgeable about what the school's process is and what it looks like, the better we can serve and advise them. Thank you, everybody. I know we have about 8 minutes left for questions. Happy to answer any now. I will also be on the panel today if we can't get through any of them.
Thanks, Jessica. Great presentation. We did get a couple questions that we answered, the assigned individuals answered, but I want to make sure that they sound good to you. So the first question, it's 2 parts. Do the students have to have an advisor, or can they choose to do it on their own? That's the first part.
Yeah, so this is a good question. Students are required to have an advisor, at least as it pertains to the cross-examination portion of the hearing. So as long as you want to go through the initial steps of the hearing by yourself, you can do that. But once you're talking about going to a hearing where that cross-examination piece is inevitable, you have to have an advisor. And so if you do not have one, the school will appoint one, again, just because you are not permitted to ask those questions yourself.
That's perfect. That answers the second part, which is if they do go it alone, can the student cross-examine the other party themselves? And I think you answered that. The answer is no.
Right.
Okay, next one is, does the recipient or decision maker question parties during the hearing as well?
Great question. And I should have said that in my presentation. Yes. So typically that is the case. Typically what happens in a hearing, and again, how decision makers do this will vary. But what I see quite a bit is that when it is time for that cross-examination piece, or that questioning piece, I should say, many times the decision maker will actually ask parties questions first. And I think that that is helpful for a few reasons. One, because when we think of your party that you are advising being cross-examined by the other party, even though those questions can't be disrespectful, sometimes the tone, sometimes the fact that it's another party's advisor can be intimidating for your client. And so I think having a decision maker, and I think some decision makers feel this way, asking those questions first can really, I don't want to say eliminate all the questions that they're going to be asked after, but it can minimize them, right? And so because decision makers typically won't allow repeated questions, if they can cover a lot of those bases, it can help minimize the questions that are asked by other parties, especially because there is more of a risk of them not being appropriate, right? Especially because advisors don't necessarily, they don't have to be attorneys, right? And so people who aren't attorneys, or maybe they're an attorney but they don't practice in this area, may not quite understand, right? We're not in court. It's a very different kind of cross-examination process. So typically, in my experience, decision makers will ask questions even before they allow the other party's advisor to cross-examine. Same thing for witnesses as well. But in my experience, I mean, yes, every decision maker is going to ask some sort of follow-up question.
Awesome. And we actually had an email question that came in, and that is, what are the things that the student has to decide or think about, I guess, on whether to participate in the hearing if they're nervous about being cross-examined?
Yeah, so that's a great question. One, I think it's very important that a student does what is best for them and for their own mental health and emotional health. These hearings are never fun for any party, right? Because even if you are the complainant and you are not the one who is technically in trouble, the respondent's advisor is very likely going to ask you questions to poke holes in your story, and maybe you experience something horrific, right? And that alone can be very intimidating itself. So I think it's important to consider what you yourself can handle. And from the respondent standpoint too, again, anything that is said through these hearings is potentially going to be shared with law enforcement if there is a pending criminal case or criminal charges come. So depending on the type of, again, allegation it is, especially in cases of sexual assault, respondents really need to be careful about what they say and how they participate, because that could affect them, obviously, later down the line. The other thing that I tell people to consider, and this is hard because when we talk about this, I try very hard not to convince a party either way how to proceed, right? But it's important that they are aware of this, that even though the decision maker can rely on maybe their interview statements that they provided, if their interview statement wasn't that great, or again, if there's a lot of holes that the party may need to explain, I think it's important to let them know that if you don't participate, they're not going to have that clarification from you, and they're going to have what the other party is saying, right? And so even though they can't hold you responsible, if you will, for not participating, and they can't count that against you, they're going to have much more limited information when they're making that decision. So there's a lot of factors to consider. I think every case is very different and every person is different. And it's not an easy choice. The good thing is that the Title IX process itself can be very long. And so you really do have a lot of time to consider that. The other thing too is that even schools that prefer for these hearings to be in person, you can always request that they be done virtually. I think the one good thing that came out of COVID is that we've learned that, we can operate virtually just like this. And so that can also be helpful and help minimize fears when you know that you don't have to be physically in a room with somebody.
Great. Well, that takes us right to the end. I don't see any additional questions in the Q&A. Thank you, Jessica. And
Thank
we're
you.
gonna, in just a minute here, we're gonna break for lunch, but if everyone could just click on the evaluation link in the chat, it's the most recent post there, and complete an evaluation for Jessica, that would be great before you leave for lunch. And then, so we're gonna take a break now and be back at 1 o'clock for a presentation by Mitch Sicken on Perez versus Sturgis Public Schools. So yeah, return at 1 o'clock. Just make sure you complete the evaluation first. Thank you again, Jessica.
Thanks, everybody. Bye-bye.